Good morning, and thank you for joining me on the path to liberty. This is the Fast Friday edition of the show for February 19th, 2021. And on this episode, I want to address a question that almost no one seems to ask about a federal minimum wage. And of course, that is it even authorized under the Constitution in the first place? I've got some brief thoughts on this from a great article we recently published by Mike Maharrey. I've got an explanation on the commerce power from James Madison, the father of the Constitution. And then I'm going to mention briefly a little-known Supreme Court opinion that was explained by Jacob Hornberger over at Future of Freedom Foundation. But before getting to that, first of all, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific Time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage is 10thamendmentcenter.com/path to liberty, all spelled out. It's got everything you need to follow this program, all the archives, individual episodes. I include a bunch of reference links so you can read the articles and citations that I'm talking about on your own time and learn more on your own time. I want to provide you the resources to take this to the next level. There's a bunch of different platforms, both video and audio, mainstream, alternative. You can find all those there, and even our membership program, where you can support us for as little as $2 a month, and we make it go a long, long way in support of the Constitution and liberty. Again, that show homepage is 10thamendmentcenter.com/path to liberty. And I couldn't be more grateful for you spending some of your time with me today. Thank you so much for being here. Whether it's your first time or you've been here for every episode since day one, I couldn't say thank you enough. I really, really appreciate it. But since it's Fast Friday, I promise to not take up too much of your time. Let's see if I can get this info out to you in the next 10 to 15 minutes. And I want to first start out with this article from Mike Maharrey. It was read pretty widely, one of the best read articles we've published so far this year. And Mike starts out by saying, hey, it may soon be illegal to take a job that pays less than $15 an hour. Of course, he says, this is a horrible policy. Wages shouldn't be regulated by the government. You must suspend basic laws of economics to think otherwise. But even if you think it's a good idea to regulate wages like this, it's not the job of the federal government. In fact, Mike says the feds have no constitutional authority to impose wage controls. But federal supremacists, and I love that he uses that phrase because these are people who think that any problem, any issue, everything under the sun needs to have a federal solution, a national one-size-fits-all solution, and one-size-fits-all in a nation of 300+ million people with a wide range of economic, political, religious, and social viewpoints is a disaster for everybody in every situation. But federal supremacists, Mike points out, will quickly point to the Commerce Clause. We always hear this, commerce. They can, or general welfare, they can do whatever they want. But that constitutional argument for a federal minimum wage is as ignorant as the economic arguments as well. He goes on, he says, when the Constitution was written and ratified, and of course, if we want to understand the original legal meaning of the Constitution is an 18th century legal document, so it means today, the words of the Constitution mean today the same that they meant when the people gave them legal force. So we have to understand what the people of the several states in the ratification debates understood the words of the Constitution to mean at the time. We can look to their conversations. We can also look to leading founders who were involved in the process because they held a lot of influence on how people actually viewed it before they said, well, yes or no to the Constitution in each of those states. And Mike points out that when the Constitution was written and ratified, the word commerce, and there's a ton of research on this if you really want to look into it. SSRN is a good place to check out if you want a website to do some digging on some law review papers. But the word commerce at the time of the founding did not mean any and every economic activity, basically anything and everything. Over time, Mike writes, the Supreme Court has basically applied that kind of a definition. And in effect, politically connected lawyers on the federal payroll have amended the Constitution to give the federal government power it was never intended to wield. And that's really what, quote, legislating from the bench is. When you take the original legal meaning of the Constitution, they give their opinion about it, and if it's wrong, people just go along with it. And then they just keep expanding power. This is a centralized system, an oligarchic type of a rule we were warned against, that these 9 unelected, unaccountable, politically connected lawyers on a federal bench will tell us what our Constitution means and the limits of federal power. Mike goes on, he says, and today, as Justice Clarence Thomas pointed out, or warned actually, in his dissent in the medical marijuana case of Gonzalez versus Raich, under the court's expansive definition of the commerce power, the federal government has no meaningful limits. He basically said if the federal government, under the Commerce Clause, can go to someone's home where they've grown 6 plants in their backyard, they never bought or sold those plants, they never took them across state lines, they consumed them on their own property, and if that was somehow interstate commerce, Thomas said, the federal government has no meaningful limits under the Constitution. Now, I talked about this expansion of federal power under the Commerce Clause through the Supreme Court over a series of 4 cases in an episode last summer. 4 cases that expanded the Commerce Clause. I encourage you to check this out if you haven't, or if you want a refresher. It also included that 2005 Gonzalez versus Raich cannabis case. I will link to that in the show notes so you can check it out. Now, going to James Madison, here's a letter to Joseph C. Cabell where he's talking about his concerns about how the commerce power, the Commerce Clause, interstate commerce clause, whatever you want to call it, could be misinterpreted and abused. He says, I always foresaw that difficulties might be started in relation to that power. It wasn't that, like a lot of people will tell us, like, oh, these people thought that everything was rock solid. The founders made a mistake. They, things were too broad or too general. They made errors and they thought this was going to be followed. Well, no, even Madison himself was concerned about what was clear to them would be abused over time. He says, it could not be fully explained without recurring to views of it, which, however just, might give birth to specious, though unsound objections. So people were going to actually abuse the power over time. He said it is very certain that the power in and of itself, why did they include this power? It grew out of the abuse of the power by the importing states in taxing the non-importing. And it was intended as a negative and preventative provision against injustice among the states themselves, rather than as a power to be used for the positive purposes of the general government. So, short version, it was to restrict blockage of commerce by the states, rather than giving the federal government an additional power to do whatever it wants in relation to any type of commerce, a plenary power. Mike goes on, he says, the bottom line is that the federal government was never intended to micromanage the economy through wage laws, labor laws, agricultural regulations, industrial regulations, healthcare laws, and the like. And I should point out that for those who love having government do stuff like this, making the case that the federal government isn't supposed to do it doesn't mean that no government is authorized to do it. That's an issue that should be dealt with on a state level, under the state constitution, under state laws, by the people of each state, how they want to deal with things in their own area. That's what a federal system is all about. That allows a country with so many people and so many different viewpoints on economics and liberty and personal sovereignty and things like that. All these different viewpoints can live together in peace rather than forcing this one-size-fits-all view on everything and anything. Mike goes on, he says, when the federal government regulates the economy and it does not directly relate to interstate trade, interstate commerce, it is usurping power and violating the Constitution. Now, Mike's article was picked up by a bunch of different places. It was republished at CNS. It was also linked to by George Leaf here over at NRO. And he, it must have got him thinking about this. He says, if someone had asked one of the founders after the Constitution was written, does this new plan of government allow federal politicians to tell us how much we may charge for our goods or our labor? The answer any of them would have given would have been, Of course not. There is no one from that generation who would have said that the federal government in and of itself had constitutional authority to dictate labor prices, goods prices to anyone or everyone at any time. And of course, he points out Meharry addresses the claim that minimum wage laws were contemplated under the power to regulate commerce among the states. He cites a pretty good authority, James Madison, that the Commerce Clause was not meant to confer plenary economic power. And as I mentioned right in the intro, I was going to cite a Supreme Court opinion on this, and Jacob Hornberger did a follow-up. FFF did link to Meharry's article as well, and then a couple days later, Hornberger published this article that I thought was really interesting. He said, the Supreme Court once held the minimum wage to be a violation of the Constitution. This occurred in a 1923 case entitled Adkins versus Children's Hospital. It was a 5-3 decision in that case. There, the Supreme Court held that the minimum wage enacted by the District of Columbia violated the Due Process Clause of the Fifth Amendment. And here, the Fifth Amendment, Jacob writes, prohibits the federal government from depriving any person of liberty without due process of law. And as the court pointed out there in 1923, the term liberty necessarily encompasses liberty of contract. That is, the right of people to voluntarily enter into mutually beneficial agreements with each other, including labor agreements. Now, of course, that did not last long. And during the New Deal and the FDR regime, the court changed course. And we know that they expanded the Commerce Clause, the commerce power, to include anything and everything. And a lot of people turned a blind eye to it because they were concerned. They needed the federal government to come and protect them and save them and fix every problem under the sun. Federal supremacists upon federal supremacists leads to precedent upon precedent and an expansion of power to the point where now the monster state we live under today is the largest in the history of the world. And I want to close out here with this one quick quote from Thomas Jefferson in March of 1801. This is when he first stepped into office, his first speech. He wanted to talk about the policies that they were going to push, the policies that his government was going to have. And he says this, a wise and frugal government, which shall... It's kind of an oxymoron, but maybe at the time it was a little different. A wise and frugal government, said Jefferson, which shall restrain men from injuring one another, shall leave them otherwise free to regulate their own pursuits of industry and improvement, and shall not take from the mouth of labor the bread it has earned. This is the sum of good government. Well, I hope you guys found this interesting. I hope it was thought-provoking. There's a lot more to dig in. This is a very short take on this. This is from one founder, James Madison, his view on the Commerce Clause. But you can also look at some other research on this as well to get an original understanding of what commerce meant at the time. And then, of course, Thomas Jefferson's policy preferences. But I think George over at NRO was absolutely correct. There isn't a single founder, there isn't a single person on the streets who would have approved the Constitution had they been authorizing centralized control over something as important to our lives as our labor costs, our wages, this liberty of contract. Again, I hope you enjoyed this episode. I hope it was interesting. I hope it's thought-provoking. I hope you learned something. If you support what we do, you like this kind of information, please consider smashing the like, leaving a review on Apple Podcasts or any other platform you may watch or listen on. Comments, links back where you're sharing it elsewhere, that all triggers the algorithm and it tells the platform to show the program to more people, and it does help a lot. Thank you to everyone who's been doing that all along or from time to time. I really, really appreciate that help. And of course, if you want to put your financial faith behind our work, there's nothing that helps us roll up our sleeves every single day and take a stand for the Constitution and liberty more than the financial faith of our members. Don't feel obligated to do so, but if you could spare a couple of bucks a month, it starts out at just $2 a month over at 10thamendmentcenter.com/members. All spelled out, 10thamendmentcenter.com/members. Thanks again for spending some time with me today. I hope you have a great weekend, and I'll see you next week here on the Path to Liberty.